All right, hello everyone. Sorry to disappoint you, but I am not in school today. As you can tell by my voice, I'm under the weather. So I'm going to be coming back in on Tuesday, but I wanted to give you guys a heads up, so at least we're not falling behind on anything. So what I want you guys to do for this lesson is basically we're going to talk a little bit about what we did last time, and then I'm going to get you guys set up for our next section. Remember, on Wednesday is going to be our quiz on basically the First Amendment's changes based on the Supreme Court cases we've talked about. So there have been several already. Your homework assignment is going to give you a kind of a full detail of what would be on the quiz. But we're going to talk about some things today that will also be on the quiz. So remember, it's going to be on the First Amendment, the Supreme Court cases that have affected it, and we might even go into the Second Amendment as well, based on how far we get in tomorrow. Well, on Tuesday. But let's get started, and we'll talk about some of the things. So last time we were in class, we did Czech versus United States. This was the homework assignment. Now we'll go over this probably when I get back on Tuesday. But to kind of give you guys just kind of a background, it's actually a pretty easy case. They basically what happened with these kids, sorry, these kind of people that were against the war was that they were basically printing out and distributing these leaflets. Well, leaflets are basically pamphlets, and they're basically trying to make them not comply to the military draft. And obviously, this was seen with a lot of backlash. People were restricting their freedom of expressing their ideas, and they were saying that this was under the Espionage Act, which basically was stating that they were acting against the government. Now, the clear and present danger test was then created based on this. All right, and what clear and present danger test is, and we've talked about this before, technically the definition is legal standard that speech posing on an immediate and serious threat to national security is not protected by the First Amendment. And basically, and we talked about this in class, the clear and present danger test is almost like the idea that if you were in a movie theater and you decided to scream fire or bomb, then basically you could be arrested. That goes against your First Amendment right. You're not protected if you're going to cause fear. You are clear and present danger to everyone else around you. Then yes, you are not protected. So this set the standard for that. So that is a really big deal because it kind of makes it so that people can say what they want, but if it causes fear to occur, then it's not going to fly anymore. So obviously, this is kind of the leaflets that they were passing around, and it was making sure, you know, I mean, it was going against this. There had people that were trying to set up registering for the war. There are leaflets that were being passed around to kind of oppose this, and obviously, we can kind of even use this idea alongside with the Ku Klux Klan and Nazis that kind of came out even after the war in 1964, because the fact is there was even a Nazi rally in Madison Square Garden, and people don't realize that you can say whatever you would like to say as long as it's not inciting fear, then you can get away with it, and that is something that you may not agree with, but it is an important concept. Okay, so now one of the next big documents we're going to go into is the idea of the press now, because remember, the First Amendment also protects the press as well. So we will probably analyze the New York Times versus United States. I think this is one of the big crucial cases. So let's get into that. So here's the thing. So the New York Times, New York Times and Washington Post were basically getting classified information from a government agent from inside of the federal government. And basically what they call that is known as the Pentagon Papers. Okay, so the Pentagon Papers basically were classified information that was given to them, and they were running the risk when they published these of publishing classified information to the public, which would be going against the Espionage Act, which was created right during World War One, right? And this was just we talked about this before with the case where the people that were giving out the leaflets go against the draft. It's the same act that they felt like they were going to kind of go against. So I'll let you guys work into this case more in detail, but basically what it does, it protects the press from being from being suppressed, right? So I'll let you guys go into it yourself, so you don't have to listen to me all day hear about it. But I'll let you guys look into it, and we'll talk about it when I get back into class. All right, and then this is going to be the next major case that we're going to look into because it goes around the idea of symbolic speech. So, symbolic speech, ironically, is very difficult to kind of narrow down specifically, right? It's really based on opinion, but symbolic speech technically is protected expression in the form of images, signs, and or other symbols. Now, it's very difficult to exactly pinpoint how do you consider something to be symbolic speech. Now, it's based on the time period, it's based on the era of how people kind of think and kind of go, believe in certain things. So, for instance, we'll look at another major case that may help you understand what's going on. But symbolic speech was also involved in a case called Texas v. Johnson. All right. Texas v. Johnson basically was the idea where Johnson was going against the war, and what he did was he had burned an American flag in the state of Texas, and what basically happens in the state of Texas now, if you do that, obviously there are a lot of repercussions because I mean even in New York and other states it might be a big deal, but in Texas there was an actual law that was stated that if you burned an American flag that you could be arrested. So Johnson had burned the American flag and was arrested in the entire case and went to the Supreme Court. And actually, it protected him from being arrested because it said that it followed in the idea of symbolic speech and that this can be protected. So, John and Mary Beth Tinkers, this is called Tinker v. Des Moines. This is another case you guys are going to be analyzing. It's a very good one, but it creates the idea of symbolic speech. So, John and Mary Tinker wore armbands at their public schools to protest the Vietnam War. They had actually a policy that would stop this from happening and that they would be suspended. So they did refuse to take off the armbands. They were suspended. But then the Supreme Court had actually struck down the school ban. It actually gave the students the rights to basically that they couldn't be refused to enter the school because of their actions of wearing these armbands. Now, I'll let you guys look deeper into the case itself, but symbolic speech is a very important topic within the First Amendment, and it actually gives a lot of people more leeway when it comes to certain things. All right, so now restrictions on free speech, what can or cannot be said. Specifically, when you look at the two major things, libel and slander. So libel is an untrue written statement that injures a person's reputation. Slander is untrue spoken expression that injures someone's reputation. So the one is written, the other one is spoken. And a lot of times it's very difficult to kind of get this through court, these ideas, but in order to win a case, they must prove the point that their reputation was slandered or hurt because of the statements that were stated. For instance, and if there was someone that their reputation was hurt in a written in a newspaper, if let's just say their job wasn't hurt or anything like that, it's very difficult for them to make that case because you need to have basically something on paper that states that, yeah, you know what, this did hurt my job, this hurt my reputation to get another job, and that's why it's considered libel or slander. Now, specifically, New York Times versus Sullivan had kind of pushed forward this idea. So what happened was in Montgomery, Alabama, official won a $500,000 lawsuit against New York Times for a full-page advertisement that basically was saying that Alabama officials using excessive force to stop student protest. They overturned the lower court's ruling and actually was stated that the advertisement was not published with malice. And you don't specifically have to know New York Times versus Sullivan, but it does create the libel and slander standard for future cases and kind of restricts free speech. Now, the problem is that when you look at hate speech and you look at all these different types of speech, the problem is that even though people do not agree with a lot of these things, they are technically allowed. Now, specifically, sometimes when you look at certain campuses and schools, that's where they kind of allow the schools to take care of most of it, and it's become more of a social issue rather than a law issue. But understand that it's really the school's, criteria to take care of those things. But a lot of times you have to understand is that it's hard to kind of kind of put down those types of ideas because they are considered free speech. We took that talked about Charlottesville in class already, where basically it was a Nazi rally march that basically was, by all accounts, seen as a bad thing. But at no point were they trying to, incite a riot. All right, and that was really the big thing, the reason why it was allowed to happen. And a lot of times too, a lot of these things, like even previously I talked about with the Nazis in the Madison Square Garden, they actually had paid for a license or a permit to have those rallies, and that's the thing that really is all you really need to have a rally of some sort, as long as it does not incite violence. Now, there's these two cases here, Roth v. United States and Miller v. California. This goes along with as well of the First Amendment of expression. Now, but the difference is now this goes more into obscenity and pornography. This one kind of makes the case that you cannot, it has to pass the Miller test. But we are not going to really go into this. This is not exactly as important as you would need to know. When it comes to regulating the internet, obviously there are certain things that you can say, some things you cannot say. There's a line that's being drawn. There's no child pornography allowed in First Amendment. If you didn't realize that, then I'm sorry to tell you, but yeah, it's not allowed. But these are all different things that can be regulated by speech. But the Supreme Court cases that I talked about before really set the standard for kind of allowing you to say what you can or cannot say. But the biggest thing is really regulating the time, space, and manner in which you can speak. Like I said before, the government puts restrictions on what you can or cannot say. Okay, it does not protect everything. There are certain things that you can say. If something is symbolic speech, it is protected. If it passes the clear and present danger test, it is protected. If it is written in a newspaper and they have gained the information correctly and it is true information, then they are protected. You have the right to assembly. You have the right to petition. However, when it comes to right to assembly and right to petition, you need to file paperwork. You need to file the permits in order to conduct these marches and in order to have these petitions. You need to go through the right barriers. The government sets regulations to make sure you jump through the right hoops in order for you to have full protection. But if you don't, if let's just say those Charlottesville Nazis kind of just did it on their own without any prior kind of knowledge to the town, then they probably would have been stopped. But the fact that they did that, it kind of allowed them to pass through the permits and for them to keep going. Talked about freedom of assembly already. This is kind of is already mentioned, so we don't really need to go into this as much. And then here's the Second Amendment. So I'll talk about the Second Amendment tomorrow. We'll go into McDonald v. Chicago. On Tuesday when I get back. But that's going to be the video for you guys. So your assignment for me, for when I'm not here and you guys are in school, is going to be the Tinker v. Des Moines, and it's going to be the New York Times versus United States. Now, this is just going to be those Supreme Court analysis worksheets. Is not going to be difficult at all. Just need you to fill out all the required information, and then once you are done, then you can enjoy the rest of your day. I will probably make it due by Tuesday night so that you will have tomorrow during class, but you will technically have the next day as well. So just to send you off on a good note. Good luck with your good luck with your stocks. Hopefully my stock is beating all of yours. All right. Have a good one.